Hello everyone. Today we are here to discuss the topic regarding to mercantile law, that is capacity of parties. So to begin with, what exactly the capacity stands for? It's the competence of the parties to enter into a valid contract. Capacity stands for whether the parties are capable enough of entering into a contract or not. As per Section 11 of the Contract Act, which deals with the competency of the parties, it provides that every person is competent to enter into a contract who is of the age of majority, first, and second, who is of sound mind, and third is he or she should not be disqualified from contracting as per the law he's subject to. Then who are the persons who are not competent enough to enter into the contract? So as per Indian Contract Act 1872, persons incompetent to enter into the contract are first a minor, second people who are of unsound mind, and third persons who are disqualified by the law, so they are subject to. So first we'll discuss, point is we'll be discussing three of these in a sequence now. So first is minor. According to the Indian Majority Act 1975, a minor is the one who has not completed his or her age of 18 years. In the following cases, a person continues to be minor until he completes the age of 21 years, where the guardian of the minor or of a personal property has appointed under the Guardianship and Wards Act 1918, where the superintendence of the minors' property is assumed to be the court of laws. Now, what are the various effects of a minor agreement? That's the most important parameter which need to be considered if we are considering the capacity of parties, because minor has so many rights in his or her favor that it's very crucial. It becomes very crucial to understand what exactly are the points which need to be considered while entering into an agreement with a minor. So the first and the most important is an agreement with the minor or by the minor is void. That's an implied action, that is that contract does not actually exist. As per Section 10 of the Contract Act, requires that parties to the contract must be competent, and Section 11 says the minor is not at all a competent to, so the contract with the minor becomes void ab initio. That is, the contract is not valid from the very beginning. The contract is not valid from the very beginning. That is void ab initio. A case here, as per the books referred, are Mori Bibi versus Dharmodas Ghosh, that is 1903. A minor borrowed 20,000 from B as a security and as a security for the same executive mortgage in his favor. He became a major few months later and filed a suit for the declaration that mortgage executed by him during his minority was void and should be cancelled. It was held by the law courts that a mortgage by minor was void and B was not entitled to repayment for any money because any agreement with the minor is void and it's void ab initio. Do remember, it's void ab initio. No ratification. Now, the most important point for an agreement with a minor is that minor cannot ratify a void agreement. That is, there is no scope of ratification in case of agreement with the minor, even on the attaining the age of majority, because void agreement cannot be ratified. Mind it, void agreements cannot be ratified. What exactly the ratify is? Ratify relates back to the date of making of the agreement. That is the date of making the agreement, and therefore an agreement which was then void cannot be made valid by subsequent ratification. If on the coming of age of majority, he promises and makes a new agreement. So obviously that's with the new constitution, that's obviously with the new guidelines, and it's all in all a new contract. And previous contract never exists because it was void ab initio. So second point was no ratification, that is, it cannot be ratified at any moment of time. Third is minor can be a promisee or beneficiary. Yes, minor can be promisee or a beneficiary. If a contract is beneficial to the minor, it can be enforced by him. There is no restriction on a minor from being a beneficiary. The General American Company Insurance Company and versus Madan Lal Sonulal. X, a minor insured, is good with the insurance company. Goods were damaged. X filed a suit for the claim. The insurance company took the plea that the person on whose behalf the goods were insured was a minor. Court rejected the plea and allowed the minor to claim his minority and claim for the insurance money. No estoppel against minor, where the minor is misrepresenting his age and has induced the other party to enter into a contract with him. He cannot be made liable on the contract. There can be no estoppel against the minor from setting up the plea of minority. That is, court may, however, require the minor to compensate the other party on the ground of equity. This is based on the rule that a minor can have no privilege to cheatment. Otherwise, there is no estoppel against minor. That is, you cannot stop the minor from claiming the age of minority. No specific performance, as the name suggests, you cannot ask for any kind of performance from the minor. Minor can be bound in an agreement, but performance cannot be expected from him. A minor contract being absolutely void, there can be no question of specific performance of such a contract. Guardian of the minor cannot bind the minor by an agreement for the purchase of immovable property. So the minor cannot ask for the specific performance of the contract, which the guardian has had no power to enter into. Liability of torts. Tort stands for civil wrong. A minor is liable in a tort. Minded. A minor is liable in case of a tort. A minor was held liable for his failure to return certain instruments which he has hired and then passed on to his friend. But minor cannot be made liable for the breach of contract by framing an action on a tort. No insolvency. Again, a minor cannot be declared insolvent. Partnership. A minor being an incompetent to contract cannot be a partner in the firm. But under Section 30 of the Indian Partnership Act, he can be admitted to the benefits of the partnership. He can be admitted to the benefits of a partnership. Minor can be an agent. Yes, minor can be an agent. Minor can be a partner. But the point is, we cannot hold liable for him for anything. So he'll not be liable for his principal for his acts. So that all depends upon the principal. If he or she want to hire and minor as an agent for himself. Minor cannot bind a parent or a guardian, though. Joint contract by minor and adult. Yes, the adult will be liable in such case of contracts, but minor won't be liable. Liability for necessities. Necessities, we all know, are those things which are essential for the survival of any human being. They cannot include luxuries or costly or unnecessary articles. The claim for necessities supplied to a minor are enforceable by at law. But minor is liable for any price that he may promise and never for more than for the value of necessities. There is no personal liability of the minor, but only his property is liable. Mind it, only his property is liable. So Imam, an infant undergraduate in Cambridge, bought 11 fancy waistcoats from Nash. He was at that time adequately provided with clothing. Had the waistcoats were not necessary, the price could not be recovered. Next, apart from minors, second was people who were unsound mind. Contracts made by the persons of unsound mind, like minors, contract are void. The reason is that contract require assent of two minds, but a person of unsound mind has nothing which the law recognizes as a mind. Person who is usually of unsound mind but occasionally of sound mind, that stands for the person who majorly remains in an unsound mind condition, but sometimes or occasionally he do become sound, may make a contract when he's a sound mind. The issue is one needs to prove that the person was in a sound mind condition when the contract was entered. Person who is usually of sound mind but occasionally of unsound mind, again the issue is you need to prove that when the contract was entered, the party was in a sound mind condition to understand the contract. So the things which you can prove, law admits that. As per Section 12, a person is said to be of a sound mind for the purpose of making a contract if at that time when he makes a contract, he is capable of understanding it, of forming a rational judgment as to effects upon its interest. For example, a property worth rupees 25,000 was agreed to be sold for only 7,000. Amount is totally, obviously, a vague and different amount. His mother proved that he was congenital idiot, incapable of understanding the transaction. The sale was held to be void. His mental powers of understanding even an ordinary matter was absent. So the lack of development of brain, and this lead to the case of an unsound mind, and the mother proved that the parties entering into a contract were not of sound mind, so the contract was held void, not valid. Who are the persons who are disqualified from entering into a contract? These are alien animals. Like when a war is declared, every contract with the opposition party or the country with which we are having a war declared is said to be alien in that case. Insolvents are never allowed to enter into a contract. These are persons who are disqualified from entering into the contract. Foreign sovereign and ambassadors, these are the persons protected from jurisdiction of local courts unless they voluntarily submit the jurisdiction. These persons have the right to contract but can claim the privilege of not being sued. So if one wants to enter into a contract with these kind of parties, they are allowed, but persons need to bear the consequences of such kind of contracts in future in that case. Example is E, who was a diplomat, was on the staff of foreign embassy and rented a house belonging to M. M sued him for arrears of rent. It was held that no action could be brought against him as he was protected by diplomatic provisions. So diplomatic provisions are an important parameter which need to be taken care. Now, convict. We all know that convicts are the people who are imprisoned and they are incapable of entering into the contract, but the disability comes to an end when the expiry of sentence is there. Imprisonment is nothing like which cannot be corrected, but it will take time. Time is a big heal in such case. Corporations, these are artificial persons created by law and can only enter into contracts within the scope of MOA, Memorandum of Association. They cannot work apart from these parts mentioned in MOA. However, they can enter into contracts concerning only their personal nature, hence are the persons disqualified by law. Professional persons are like doctors and advocates are included in this class. In England, for example, barristers are prohibited by the etiquettes of their profession from suing for their fees, whereas in India, these personal disqualifications do not exist. So, according to Bar Council Act 1927, an advocate of the High Court can enter into a contract with his client and can bring a suit against him for his fees. Good luck, and soon next chapter will be covered. Till then, good luck for your futures. Thank you.